In the UK construction industry, collateral warranties and third-party rights are two legal mechanisms used to extend contractual protection to parties who are not part of the main building contract. These mechanisms are particularly relevant for funders, tenants, purchasers, or other stakeholders who have an interest in the completed development but are not directly involved in the construction process. While both tools serve a similar function, they differ in structure, practical implementation, and legal consequences. A collateral warranty is a separate agreement typically executed as a deed between a party to the construction contract, such as a contractor, subcontractor, or consultant, and a third party, such as a funder or tenant. It provides that third party with direct contractual rights and obligations, often mirroring those in the main contract. For example, if a structural engineer designs a building as part of their contract with the main contractor, a collateral warranty may be provided to the funder to ensure that the funder can claim against the engineer for defects. Collateral warranties are often bespoke and may include obligations such as maintaining professional indemnity insurance, giving step-in rights, allowing the third party to take over the contractor's role in the event of default, accepting liability for design defects or workmanship. A key characteristic of collateral warranties is that they create a direct contractual relationship between the construction professional and the third party, giving rise to enforceable rights and duties under English contract law. Third-party rights are generally governed by the Contracts Rights of Third Parties Act 1999, which allows a third party to enforce terms of a contract if the contract expressly states so, or if the contract purports to confer a benefit on that third party. In construction contracts, parties can specify within the main contract that certain third parties, named or described, shall have the right to enforce specific provisions, usually using a schedule of beneficiaries and the particular clauses they may enforce. This method removes the need for separate agreements and can be more efficient, especially when dealing with multiple stakeholders. However, it depends on the clarity of the drafting to ensure enforceability and protection. Key differences. Form. Collateral warranties are standalone contracts. Third-party rights are embedded within the main contract. Administrative burden. Warranties require multiple separate documents and signatures. Third-party rights reduce paperwork and time. Flexibility. Warranties can include tailored obligations. Third-party rights are limited to what's written in the main contract. Enforceability. Both mechanisms offer enforceable rights, but warranties are more traditional and widely accepted in practice. Negotiation and timing. Warranties can be negotiated and signed at different times. Third-party rights must be built into the original contract, or amended accordingly. Both collateral warranties and third-party rights are crucial tools for extending legal protection in the construction industry. The choice between them often depends on project complexity, number of stakeholders, and the party's preference for traditional versus administrative efficiency. Ultimately, clear drafting and legal advice are essential to ensure these rights serve their intended purpose effectively. Metroun, a commercial hub for your business.